It's not a good thing. And as I get older, there's a lot of things that bug me.
But I never noticed.
Let's talk employment law.
We've never done that before.
Today's the day.
All right, let's do it for the first time. Well, it's a good time that you want to talk employment law because a major decision came from the Ontario Court of Appeal. And so to set the stage for it, if we go back years, Supreme Court of Canada said very clearly, and perfectly logical, that employment agreements have to be drafted so that they meet minimum standards requirements. Employment standards legislation across Canada, the employment agreements, in order to be enforceable, effectively have to meet the standards set out in minimum standards legislation. Great. But what happened since then, and particularly in Ontario, is you have innovative plaintiff lawyers that start picking apart the language in the employment agreement. And what you ended up with was employer significant uncertainty as to whether their employment agreement would ultimately be enforceable, even though the employment agreement makes references to, hey, we intend to comply with the employment standards legislation. So cut to this Court of Appeal decision where essentially what you have is an argument for the Court of Appeal on whether the inclusion of at any time, in other words, typical language where an employer can terminate the employee at any time, and the language that says for any reason. Now, those are sort of almost, I was going to say motherhood language, but it's language that's almost from convention been included in employment agreements for years. And 100% of employers would say that the inclusion of that language doesn't signify in any way an intention not to comply with the employment standards legislation. But what happened is you had lower court decisions that said no. It appears based on that language that the employer may be intending to violate the employment standards legislation. So that found its way to the Court of Appeal. There were two conflicting decisions, which is why the Court of Appeal had to hear it. And the Court of Appeal said, no, that doesn't make sense. They said, so the plaintiff lawyers, just so you understand, on at any time. So if you include the employer can terminate at any time. Well, plaintiff's lawyer's position, and lower courts that accepted it, was that, well, hold a second, any time. What if somebody's coming back from a maternity parental leave? You can't just terminate at that point in time. It may be a violation of the employment standards legislation. Therefore, that reference renders the termination provision unenforceable. And similarly, for any reason. Well, could it be a reprisal situation, which is a violation under employment standards legislation? So, therefore, that would render the termination provision unenforceable. So the Court of Appeals listening to this, and the Court of Appeals said ultimately, no, we don't buy it. Just because there's a hypothetical possibility that with that language, the employer may violate employment standards legislation, in essence, what you're doing, lower courts, is you're striving to find an ambiguity. Mm-hmm. And the Court of Appeal just said, no, that doesn't make sense. That what you have to do is, if the employer, through the contractual language, clearly demonstrate an intent to meet the employment standards legislation, then you can't engage in this exercise where you're trying to find ambiguity and multiple interpretations regarding the language. So the Court of Appeal really ultimately went back to standard contractual principles, although recognizing employment is not a normal commercial agreement, but nevertheless, you have to apply, let's call it, somewhat standard approaches to the interpretation of employment agreements. And therefore, now you're in a situation in Ontario where many of these employment agreements that were formerly unenforceable would now be enforceable. That's not to say, however, that plaintiffs' lawyers won't seek to be innovative once again and make arguments that render termination provisions in particular unenforceable. What have you read poetry today?